I am going to talk today about a legal strategy called the Black Rage defense. It is the basis for this book that I wrote entitled Black Rage Confronts the Law. This book discusses the history and the present-day struggle to force the legal system to allow evidence of racism, poverty, and culture into the legal system. But first, who the hell am I to be making this presentation? Let me introduce Tosh Harris Santiago, who will do the relevant introduction of me.
Paul Harris is considered the modern-day pioneer of the Black Rage defense. He has been written up numerous times as one of the greatest lawyers in America. Paul co-founded the multiracial San Francisco Law Collective, where lawyers and legal workers were equal partners. He taught criminal trials and guerrilla lawyering at 3 schools. And he was a former president of the National Lawyers Guild. Now I can say so many nice things about him because he is my grandfather. But let's get back to the lecture.
A number of years ago, the California Court of Appeal said that, quote, one of the guiding principles in every courtroom is that race is a neutral factor. It does not count for or against anybody. You and I know that this is bullshit. Yet it is the guiding principle of American law, especially criminal law. The law, through its rules of evidence and precedents, tries to keep a class and race out of the courtroom. The Black Rage defense attacks, challenges this dogma. It says that the myth of the colorblind courtroom is just that, a myth that supports the establishment, the power structure, the existing systematic racism of the legal system. What is the Black Rage defense? It is a legal strategy, a theory of the case, which uses evidence of racism, of poverty, of culture, to explain a client's behavior. In the criminal law context, which is 90% of the cases, it shows how society is an accomplice to crime, how society is a co-conspirator. In addition to explaining why and when to use the Black Rage defense, in the book I describe the Colin Ferguson multiple murder case in New York to show that there are times when it is a losing legal strategy and by creating stereotypes is a bad political choice. Now there are numerous ways to use the Black Rage defense. In a criminal case, 1, acquittal at trial. 2, plea bargaining. 3, to reduce sentencing. 4, to negate specific intent. For example, lowering murder to manslaughter. 5, it can explain state of mind issues. Let me explain that. For example, if you leave the scene of a crime, it can be called flight, and the judge will instruct the jury that flight shows a consciousness of guilt. The Black Rage defense allows you to explain why a black man might run from the police even though he is innocent, and therefore it is not consciousness of guilt. 6, it can be used as evidence of mitigating factors in death penalty cases, and I will discuss later one of the cases where the mitigating factors saved a prisoner from the death penalty. And then in civil cases, there are many applications which help win a case or increase damages. Now it is important to understand that the Black Rage defense is not a separate defense. It is not a standalone defense. For example, if you are charged with robbing a bank, you are allowed alibi evidence. It's a separate defense. If you prove that you're not in the bank, you have an alibi, you can be acquitted. But if you shoot your white supremacist boss, you can't get an acquittal with a defense that says, he treated me in a racist way. The genius of the Black Rage defense, and the reason it has not been denied by the legal system, is that it takes traditional legal defenses such as insanity, diminished capacity, duress, self-defense, and it puts the Black Rage evidence into those traditional defenses. And that way it's similar to the battered woman evidence defense. It is similar to the GI post-traumatic stress defense. All three defenses use social reality. That is reality that you and I know. Evidence that we know are true. It uses that to explain a client's behavior, which at first glance seems to be intentionally criminal. And it uses it to explain behavior that jurors don't understand. Let me read a few pages from the book about one of the two seminal cases of the modern Black Rage defense to show you how it actually works in practice. In July 1970, Stephen Robinson, a 29-year-old black man, walked into a bank in the Fillmore district of San Francisco, pulled an unloaded .22 caliber Derringer out of his overalls. He lined the 4 women tellers up against the wall and emptied each cash drawer into a striped laundry bag. As he went from drawer to drawer, 2 police officers, responding to the silent alarm, came into the bank. One drew his service revolver, ordered him to drop his Derringer. After Robinson dropped his gun, the police began to handcuff him. The 6-foot Robinson suddenly turned and began to fight. The 3 men punched and kicked each other until finally one of the police got his baton against Robinson's neck and choked him into brief unconsciousness. As they walked out the front door, a large crowd of black people from the neighborhood gathered around. Robinson, his hands cuffed behind him, his nose streaming blood, suddenly stopped, held his head high. Looking at the crowd, he shouted, "Why are black people without homes, without jobs, when there is so much money in America's banks?" People began to applaud. The police hurriedly pushed him into the squad car. In 1971, a Detroit auto worker named James Johnson went to trial for murdering his foreman and 2 other men in a Detroit auto plant. James Johnson was defended by legendary African-American lawyer Kenny Cockerell and people's lawyer Justin Ravitch. He was supported by the community, by black union workers, and was found not guilty by reason of insanity. At approximately the same time, Stephen Robinson went to trial in San Francisco for bank robbery. In both trials, the political reality of what it means to be black in America became an essential part of the defense. These trials marked the modern development of the Black Rage defense. The term Black Rage often evokes violent, aggressive images, but the Black Rage defense encompasses a broader view of African American life than just anger and violence. It includes pride in one's heritage. It explains hopelessness and sheds light on the darkness of fear and abuse. Most of all, it says to the American legal system, you cannot convict me without hearing who I am and what has caused my behavior. You cannot convict me until you know what has shaped me. I was not born with a gun in my hand. My childhood dreams were not of robbing banks and shooting people. Back to 1971. The loud, harsh clanking of the steel doors, the stink of food and sweat. I was entering San Francisco County Jail. Stephen and I met in one of those tiny, airless rooms set aside for lawyer-client conferences. He was both mistrustful and happy. He didn't know me or the community activists who had sent me to the jail to see him, but he sure needed a lawyer. We went over the facts briefly. I agreed to take the case, hoping I could get the federal magistrate to appoint me so our law collective could get paid. As I left the jail, I had no idea how I would fight the case. He had been caught red-handed. So I focused on getting him out on bail, and 2 days later the federal magistrate released him on his own recognizance. Over the next 2 months preparing, I got to know Stephen's life. I learned he was a musician who taught at the Malcolm X Free School in the Western Addition. He was also a skilled draftsman who, after 30 applications were turned down, finally, with the help of the Urban League, got a job. But he was the first one laid off. His wife and little girl had been sick. The doctor at the Black Man's Free Clinic told him he needed to see a specialist, but he had no money. He said that as a black man, he was responsible for providing for his family, unlike what his father had failed to do for his mother and him. A man of great pride, Stephen told me that he would not beg the white power structure for welfare. A plan for trial began to form in my mind. I believed I could fit together 3 elements: Stephen's personal life history, what it means to be black in America, and the law of insanity. I grew more and more excited. I read the bestseller Black Rage by African-American psychiatrists William Greer and Price Cobbs. I reread Wretched of the Earth by West Indian psychologist Frantz Fanon. These books have a common theme. Oppressed people turn their rage against themselves, causing mental illness and crime. I certainly knew that rhetoric alone would not persuade a jury. Yet the truth of these books, written by men who had examined and treated hundreds of people, could not be denied. There was a link between social existence and crime. There was a nexus between racism and acts of criminality. Stephen Robinson had committed a criminal act, but he was not a criminal. He was not classically insane, but I felt confident that I could fit his life into the then prevailing federal definition of insanity. I felt I had a defense. I was excited. Stephen didn't agree. "How many jury trials have you had?" Stephen asked me on April Fool's Day. "None," I replied, "but I spent a year as a law clerk for one of the best federal judges, and I watched lots of trials and discussed and dissected them with him." "How old are you, Paul?" "I'm 28, but I won my practice trial in law school in Berkeley, and I've won both trials I've had in federal court." "Do you know anyone who has done this kind of defense?" "No, but Clarence Darrow brought the reality of racism into court in 1925 when he defended Henry Sweet, who shot into a mob of white people who was attacking his home. And Charles Gary did the same when defending Black Panther leader Huey Newton for shooting a cop. Of course, those were self-defense cases. This is different." "Yes, Paul, this is too different. It won't work." And then he left. He really left. In my 50 years of practice, Stephen Robinson was the only client who jumped bail. 6 weeks later, Stephen was arrested in Savannah, Georgia, after a traffic stop. He was returned to the San Francisco County Jail, where I once again sat with him in the small, airless interviewing room, Stephen was depressed. He could not be consoled. He had no hope. He just wanted to get it over with. I'll do my 5 years in prison, Paul. I'm going to plead guilty. That's it. A black rage defense was the furthest thing from his mind. A few days later, I walked through the Kafka-like hallways of the federal building on my way to court. I could not help but recognize that as in this hallowed building of the law, all 8 judges were white, all the prosecutors were white, all the bailiffs were white, all the marshals were white, all the secretaries and law clerks were white. Everybody was white except the defendant. We stood in court facing United States District Court Judge Stanley A. Weigel. Judge Weigel was a liberal in matters of civil liberties, but he was harsh with criminal defendants, and even harsher with lawyers. One lawyer I knew often threw up before doing trials before Judge Weigel. But one thing you could count on, he would give your client a fair trial. The judge began to take Stephen's guilty plea. You know you have a right to remain silent and not incriminate yourself. Do you waive that right? Yes, I do. You have a right to call witnesses in your behalf. Do you waive that right? Yes, I do. You have a right to confront and, through your lawyer, cross-examine all witnesses. Do you waive that right? Yes, I do. You have a right to jury trial, a jury of your peers. Do you waive that right? There was a pause. If I had a jury of my peers, I would be found not guilty. The judge stared at the defendant. What do you mean? If I had 12 people who were really my peers, they would understand what I did, I'd be found not guilty. The judge leaned forward, his eyes piercing into mine. This is not a guilty plea, counsel. You told me it was a guilty plea. I had been taken completely off guard by Stephen's statements. I quickly asked for some time to confer. The judge motioned to the U.S. Marshals. Take the defendant and his lawyer, put them in the holding cell until they can straighten things out. For half an hour, Stephen and I sat in the cell behind the courtroom as once again I explained my idea of a political psychiatric defense. Once again he refused, feeling it was hopeless. He said he'd plead guilty, he'd answer all the judge's questions the way the judge expected. We returned to court, went through the litany of rights one waives when one pleads guilty. But when the judge got to the part about a jury of peers, there was only silence. Then Stephen spoke out. If I had a jury made up of people from Fillmore and Ellis Streets, I would be found not guilty. Judge Weigel was seconds from exploding. This is not a guilty plea. I refuse to accept this plea. You are going to trial. At the time, none of us expected that a new legal defense would come from Stephen's stubborn refusal to accept a white legal system. 4 months later, an all-white jury found Stephen Robinson not guilty by reason of temporary insanity. And according to the federal law in 1971, he walked out of the courtroom right there, a free man, accompanied by his wife, his daughter, his fellow teachers, and students from the Malcolm X school. The jurors had come to understand Stephen Robinson's life and the tragic consequences of racism. That is why they found him not guilty. What happened in that case is similar to a trial in 1998 in New Jersey, where an all-white jury refused to impose the death penalty on an African-American inmate, Stephen Beverly, who had admitted murdering a white guard who had acted in a racist and homophobic way towards Stephen and his cellmate. The jury understood Stephen Beverly's rage was born out of the effects of racism, homophobia, and administrative denial. They found him guilty, but refused to impose the death penalty. The jury stated the following unanimously, quote, "The Bayside administration permitted and fostered an environment in which racism flourished, and the administration did not properly respond to Beverly's complaints so as to minimize or eliminate the anger and frustration which caused Stephen Beverly to commit the offense." These cases show that white people can't understand the effects, the tragic effects of racism. We are all human beings. We can all understand common feelings once we are educated to them. The lawyer's role is to educate, to expose racism, to expose poverty, to expose the class system, and to put them into the traditional defenses of the legal system, and to force the legal system to confront racism. And in this way, we protect the dignity of our clients. And our clients have thanked us many times, even when convicted, for helping them understand themselves, helping them understand the causes of their behavior, and to preserving their pride and their dignity. In conclusion, let me go to Khalil Gibran, the great writer and poet, from his classic work, The Prophet. "The righteous is not innocent of the deeds of the wicked, and the white-handed is not clean in the doings of the felon. Yea, the guilty is oftentimes the victim of the injured, and still more often the condemned is the burden-bearer for the guiltless and unblamed. You cannot separate the just from the unjust and the good from the wicked, for they stand together before the face of the sun, even as the black thread and white are woven together."
If you appreciated this presentation, make sure to check out my grandfather's YouTube channel, Paul Harris, Guerrilla Lawyering, in the next 2 months. It'll make him really happy. He will be doing the following topics: how to survive as a people's lawyer, what is guerrilla lawyering, how to win using the theory of the case, and finally, violence against women in the legal system. There you have it. Thanks.